You're listening to People, Places, Planet, the official podcast of the Environmental Law Institute, a nonpartisan, nonprofit research and education institute making law work for people, places, and the planet. If you enjoy the podcast and want to support our work, consider donating at eli.org/donate.
Welcome back to another episode of People, Places, Planet. I'm your host, Sebastian Duque Rios, and in today's episode, we're deep diving into Monsanto versus Durnell, a Supreme Court case that could reshape toxic tort litigation in the United States and determine whether individuals and communities can still hold pesticide companies accountable at the state level when their products cause harm. Today, I'm joined by Patti Goldman, a senior attorney at Earthjustice, and Cecilia Diedrich, a staff attorney at ELI. Patti is a leading figure in pesticide litigation, while Cecilia currently leads ELI's plastics and toxics work. Would each of you like to briefly introduce yourselves and your connection to this work? Maybe starting with you, Cecilia.
So happy to be here. My name's Cecilia Diedrich, staff attorney at ELI, leading ELI's cross-cutting work on toxics and then also on plastics issues. Our team has been recently working on publication on current trends in toxics litigation, which is now available on ELI's website. And through this work and looking at these cross-cutting toxics issues, pesticides have been a major focus of litigation for decades, and it's been ramping up in recent years. And as well as this being a significant space, there's a major legal battle taking place. And that's why we invited Patti Goldman here today to share her expertise on the case going before the Supreme Court and to discuss the broader context of these issues.
And I'm Patti Goldman, a senior attorney with Earthjustice. And even before coming to Earthjustice over 30 years ago, I was working on pesticide issues at Public Citizen Litigation Group and started working on the preemption issue. It all started with the Supreme Court decision in Chip alone involving cigarette warnings, which Congress mandated. Congress specified the language and said states can't have different labeling. And the Supreme Court said that preempted state tort liability, state failure to warn claims. And every industry then decided to try to make it like Chip alone. Any label that went through any kind of a federal approval process, they argued would preempt state failure to warn claims. And I worked with Arthur Bryant, who was then the head of trial lawyers for Public Justice, now Public Justice, to develop the arguments to counter that. And in simple terms, it's very different because under our federal pesticide law, it's not Congress that wrote the label or EPA, it's the manufacturers. They write the labels, they submit them to EPA, but they have a duty to make sure their label has adequate warnings and directions for use to protect human health. And we argue that's fundamentally different. The courts were quite split on that, but I think we'll discuss it ultimately started to say this is very different, and hopefully will continue to do so in the Durnell case.
Well, thank you both very much for joining me today. I'm very excited to have you both on this episode. And before we dive into the Monsanto versus Durnell case, let's step back to give our listeners some context on pesticides and their regulation. What harms do pesticides pose to workers, communities, and ecosystems, and how are they regulated in the United States?
Sure. Well, pesticides are meant to kill. So it's not like a consumer product that's put out there just to do something hopefully that is good. They're meant to kill pests. And so they're inherently dangerous. When people come in contact with them, wildlife, water, sometimes the crops themselves, they can be very dangerous. In terms of human health, we have a lot of acute toxicity, and workers in particular are on the front lines, the most exposed when they apply pesticides, when they go into the fields that have been sprayed. People who live near the fields, children in particular, are exposed to pesticides that drift away from where they're applied. And the illnesses can be acute poisonings, like the worst flu you can imagine, or they can be lifelong harms, like cancer, like Parkinson's disease. Or one that I've worked on for a long time is impacts to children from in utero exposures that cause autism or learning disabilities that then are with the children throughout their lives. So it can be very dangerous. Our pesticide law is called the Federal Insecticide, Fungicide, and Rodenticide Act, or FIFRA, establishes a scheme where EPA will register pesticides, but it is not a purely health-based standard. It is a balancing standard. It's called unreasonable adverse effects. That's what EPA is supposed to avoid. But it makes that determination taking into account all of the costs and benefits. And so what I've seen, one of the pesticides I've worked on is paraquat, which is an herbicide. It's been associated in a lot of studies with Parkinson's disease, but even completely non-controversial is the science associating it with lung damage and kidney damage, and it's acutely toxic. A single sip can kill is what the labels have to say. It's so toxic. Well, in EPA's assessment, it found very severe risk to workers. And then it did an analysis of what it would cost growers if they couldn't use paraquat. And for some of the risks, it decided it would allow the risks to the applicators or people going in the fields because it would cost too much for the growers to use an alternative pesticide. That's the law we have. It can have that kind of a balancing. So it is not a safety standard. In fact, to say that pesticide is safe is not allowed under the Act because that's not what EPA is guarding against.
And I'll also flag for our listeners that if they do want a deeper dive into FIFRA, we've actually covered FIFRA in our Explained series before, in our FIFRA Explained episode, and I'll be sure to put that in the show notes. But particularly relevant to the case at hand, Patti, is the process that EPA goes through to approve a pesticide label. So I'm curious to hear a little bit more about that. And I think you've kind of hinted at the answer to this, but essentially, does the EPA approval of a pesticide label mean a product is safe?
It absolutely does not. What EPA will do when it originally registers a pesticide, it will look at the different risks and it will say, oh, don't apply more than once a season or in this amount, or it can be sprayed from airplanes or it cannot. How long do the workers have to stay out of the fields? And all of that will make its way onto the label. The manufacturer, though, is the one that will write that label. And there are a lot of things the manufacturer can put on the label that are not required by EPA. It may decide to have a warranty or a disclaimer, or often we see warnings, cancer warnings around there, even when EPA hasn't required that. But there are a couple of important features about the label, is that once it is accepted by EPA, and that's the language, it doesn't actually approve it, it stamps the label accepted through a very informal process. But then the manufacturer can submit a new label whenever it wants. And it can change things, and they do that regularly. And sometimes EPA will do a pretty cursory review when there's no new data analysis. And sometimes it will allow the manufacturer to add things to the label just by notifying EPA. Like if there's a new state use restriction, the company can put it on the label and EPA just will receive it. They won't even stamp it, accept it. And so the manufacturer must make sure that its label is not causing misbranding. And that is defined in two ways that are particularly relevant here. First, there cannot be false and misleading statements on the label. And second, the label has to have warnings and directions for use that are adequate to protect human health. If the companies get evidence that there are harms out there or new scientific studies, it has to submit those to EPA upon penalty if it does not. And if it needs to change the label to make sure it's adequate to protect health, it has to submit a new label. And the fact that EPA had stamped a prior label accepted as part of registration is not a defense. And this is a really important part of FIFRA. Registration, which includes accepting the label at the end of the process, is not a defense to any offense under FIFRA. And that includes misbranding. So the fact that EPA took that label, stamped it accepted, doesn't mean that it is cast in stone. It has to change when circumstances warrant.
Thank you, Patti. I think it's really important for our listeners to grasp and understand what exactly that stamp means, because I do think there is probably a misconception among those who aren't experts that stamping is, for one, probably a much lengthier legal process, and for two, that it actually kind of is more of a safety standard. So it's good to clarify that it is about balancing, right? And speaking of balance, another aspect that is really important to this case is that division in authority between the federal government and the state governments. So could you tell us a little bit about how FIFRA divides that authority, and how have state programs historically served to enhance pesticide safety?
Yes. So FIFRA expressly preserves state authority to regulate the use of pesticides. And what that means is a state can decide to ban a pesticide that EPA has approved. A state can say, we're not going to allow aerial spraying, which is inherently dangerous because it can drift really far from where it's applied. A state can decide to have buffers around schools and daycares and playfields because of the potential for the pesticide to drift into those areas and affect children. That is its authority. Nobody is contesting that. And I'd love to give a couple of examples of how that has worked. There are a lot of synergies between state regulation and federal regulation. So one involved an organophosphate pesticide. You may hear a bunch of that from me because I've worked on those for many decades. They are neurotoxic. They're in the same class as sarin gas, different nerve agents. In fact, the Nazis were trying to develop them into nerve agents in World War II. They didn't use them in the war, but if you formulate them in different places, in different ways, then they're used as commercial pesticides. There were about 4 dozen different formulations of organophosphates used in the United States in the 1980s when I started this work. One is called phosgene, very acutely toxic. And it was used in Washington State, where I live, for the first time in 1993. And dozens and dozens of workers became sick. And the state stepped in to say, okay, we're going to need more warnings, more training, more ways to protect the workers. And then as the course of that summer went on, the state banned the pesticide. California also had a lot of experience with worker poisonings and put a lot of protections in place. EPA was lagging behind. It was going through a process, and it had drafted a notice that it was intending to cancel the product. What happened next is the company cut a deal and said, let us use it a little longer. And then EPA said, okay, but we're going to put the California protections in place on the label during the period that you could continue to sell this pesticide. And eventually then it was banned, canceled, but essentially the writing was on the wall. So there were synergies. There you had EPA start to regulate, to draw from the state protections, and eventually the company realized the writing's on the wall and gave in. So another example is more current, also an organophosphate called chlorpyrifos, where there was a lot of concern about not just acute poisonings, but also a growing body of evidence from leading academics that was correlating exposures during pregnancy with learning and behavioral impairments in the children. And so some states were starting to pass laws to ban the pesticide. California started up 2 processes, one to have it declared a reproductive toxin, which would require warnings on the label. The other was to have it declared a toxic air contaminant. And as that moved through the process, there was going to be an enforcement kind of proceeding with discovery. And the main maker of chlorpyrifos, Dow AgroSciences, decided to stop making the pesticide at all. And so you have first restrictions in California. There was almost a near ban in California, and then the company just said, okay, I'm going to stop. Now, there was something else going on. There were lawsuits filed by families whose children were affected. The mothers were exposed in pregnancy. So you had tort litigation going on. You had California get a near ban, and then other bans in other states, and the company gave in. Now, we still have other companies stepping in, seeing this as a market opportunity to fill that void. So chlorpyrifos is not gone, but its use is sharply reduced from what it used to be.
Patti, you just mentioned tort litigation, and I want to give our listeners an opportunity to get a better sense of the difference between tort litigation and maybe what we more often hear with environmental statutes, which is the citizen suit provisions. And so before we discuss some of the litigation in the pesticide space, what are tort cases and what role do they play in facilitating disclosure, accountability, and regulatory reform when it comes to pesticides and toxics, even so more broadly?
Yeah, this is one of my favorite law school anecdotes, but as my tort law professor said, when none of us really understood what a tort was, a tort is simply a civil wrong or a civil harm. And you have to think of it as personal injuries, property damage, product liability. But in this case in particular, it's relevant to environmental harms and personal injuries. So tort cases are legal actions brought by groups or individuals who have suffered due to the wrongful actions of another party. And while these are common law principles, a lot of times tort and tort claims are governed by state law. And that's where that connection comes into play. So tort law at its core helps to hold wrongdoers accountable. That's where that accountability comes in. And that's where litigation plays such a foundational role in our legal system. And importantly, tort cases can facilitate disclosure of information through discovery, as Patti has mentioned. It's a phase of litigation where parties request and exchange information and evidence that's relevant to the case at hand. And in toxics cases, internal corporate documents revealing knowledge about potential hazards or risks are critical for establishing causation. Tort litigation also highlights failings in our regulatory system that put people or the environment at risk and can lead to regulatory reform or corporate behavior change. And I'd say regulatory reform at both the state and federal levels. As Patti was discussing, a lot of times this starts at the state level and leads into federal reform or change of statutory language over time.
I'd love to give an example of the synergies between tort litigation and EPA regulation and manufacturers changing their behaviors, because that's what I see. I mainly work in the federal regulatory space, but then when you have tort litigation that forces disclosures of what the companies did and maybe malfeasance on their part and people were harmed, you start to get EPA action. And so back to chlorpyrifos. I mentioned this. Chlorpyrifos was used in two different ways. It's still used in agriculture, but it was also used for termite control and other insect control. It would be sprayed in the home. There were a lot of people who got very sick, including children. And there were a lot of lawsuits that were filed against Dow. And this was in the 80s and 90s. And one of the cases, the lawyer got a lot of information in discovery about what Dow knew and what it didn't tell EPA. Studies that showed the kinds of harms from this pesticide. And under FIFRA, the manufacturer, or anyone actually, has to give EPA adverse effects information. It has to give EPA new scientific studies, poisoning events, and information that's generated in discovery, like expert reports, expert testimonies, those kinds of things. And Dow did not submit that. And when it was brought to EPA's attention, EPA fined Dow. It was the largest civil penalty to date. And then the information was submitted and then was updated. And what that led to then, as EPA was regulating, there was one of the EPA scientists analyzed this information and recommended a series of label changes to afford greater protection to people. And Dow did that voluntarily, kind of under pressure. And then EPA was doing its risk assessments and was reviewing the older pesticides to see if they could pass muster. And it found children were exposed to really harmful levels in the home. And that led to a phase out. So rather than have EPA take regulatory action, and from EPA's part, that takes time, the company agreed to phase out the use of chlorpyrifos in the home. And that ended around 2000. I mean, the existing stocks could be used for a little while longer, but no new chlorpyrifos could be sold after that. And so we saw those synergies. You see the synergies of information's generated, it goes to the regulators analyze it, decide maybe more is needed. And as they're gearing up to act, the company will say, okay, I'll cut a deal. Just let me sell the product a little longer, let people use it, but you basically get a phase out.
Thank you, Patti, for that example. And now that we have that kind of base from those examples to understand those synergies that occur between what's going on at the state level and what ultimately ends up happening at the federal level, whether it's by regulation or even through a voluntary phase out, I want us to take a moment to walk through some of the long-running history, specifically the litigation over Monsanto's glyphosate product, Roundup, which is at the heart of this case, right?
So Roundup is a widely used herbicide. It may be among the most widely used in the United States. It's not as acutely toxic as a lot of the other pesticides that are used, but for applicators who apply it, there can be a lot of exposures, more than what people are exposed to, say, in food. And so what we started to see, particularly with applications in residential settings where they're using handheld sprayers, that there was a lot of exposure. A lot of people got non-Hodgkin's lymphoma. There are a lot of lawsuits against Monsanto from the people that were injured. So there was no protective clothing required, no gloves, no masks, the kinds of things that you'll see when you're trying to prevent exposure. Things like chemical resistance aprons, nothing like that was required. And over time, the evidence of a link between glyphosate, the active ingredient in Roundup, and cancer started to emerge. EPA classified glyphosate as a potential carcinogen in 1985. And then there were studies that were coming out, and Monsanto hired a toxicologist to review them, who said there's evidence of carcinogenic linkage, genotox kind of cancer link, and that it looked like there might even be a greater link for the formulated product that has added chemicals than for glyphosate itself. So what emerged in the course of the cases and at trial is Monsanto started to say, hey, I don't think we want to use this guy anymore because he's not saying what we want. We're going to have to find somebody else who will dismiss this link and be a real voice for us to influence regulators. So it looked around to find somebody else and found a set of scientists who would put their name on an article that Monsanto essentially wrote. So it was ghost written by Monsanto, but published under the names of others. And this all emerged in the course of the litigation. And so the cases eventually, a lot of them went to trial. There were some very large jury verdicts. And Monsanto is just scrambling to try to be immune from liability in these cases. As a postscript, because of the information that came out in the discovery process in these cases, the journal that had published the ghost-written article retracted it last year, which is a pretty big step. And it was all because of the information that emerged in the course of the litigation.
So to backtrack a little bit and talk about the legal concepts that brought this case to be what it is, apart from the people who were harmed and the people involved. And I think it's always important to remember the human side of things and that there are people being harmed at the basis of tort cases. But in the context of the legal side, part of what Patti was discussing is on the Roundup labeling, there are the federal requirements, but there was the lacking information about how to properly use the product and prevent a known risk from harming the users. So there's this concept in almost all product liability cases in tort law, and it's foundational to toxics litigation or used in most toxics cases in general. There's a failure to warn claims, and we wanted to talk about why they're so central to these types of cases. So failure to warn claims have become a dominant feature in pesticides cases, as well as most product liability cases. The claim, in essence, is that a manufacturer or seller did not adequately inform consumers about the risk associated with using the product. And to do that, plaintiffs must typically prove that the product was dangerous without proper warning. The manufacturer knew or should have known about the risks associated with the product. A reasonable, adequate warning could have prevented the injury, and the lack of warning caused the injury. So as Patti was discussing with the emerging scientific information and evidence that came out of discovery, there was internal knowledge on the part of the corporation that they knew there were risks associated with use of the product, and they failed to adequately warn users of that product, and that the product, through the scientific evidence, we can see that it caused various health injuries.
Have these failure to warn cases primarily been in state courts or in federal courts? Like, what role have state courts played in that failure to warn, right? And how has that led us up to where we are now?
So state law fills kind of the gap left by FIFRA and can build on FIFRA as a statute, as Patti mentioned, with use restrictions, but also a lot of state law codifies some sort of failure to warn claim. And that's where these kind of cases and this issue of preemption, whether federal law preempts state-based law failure to warn claims, has come up as an issue over and over again.
Now, let's turn to the case currently before the court. Could you give us some background on Monsanto v. Durnell, and what is the question that the Supreme Court is being asked to decide?
Sure. So this is one of many, many cases that are making their way through the courts. And what Monsanto has argued is that the fact that EPA approved the label that's on Roundup insulates Monsanto from any failure to warn liability. And this is under the doctrine of federal preemption. So the argument is that the federal law, FIFRA, preempts any state failure to warn claims. There are two doctrines of preemption that underlie this claim. One is express preemption, where there is a preemption clause in the statute, and there is one in FIFRA. And then the other is implied preemption, because Monsanto is arguing that it would be impossible for it to provide a cancer warning on the Roundup label, which is what a jury verdict might be suggesting it should do. So that is pretty much the question that is presented.
The Supreme Court addressed some similar arguments in Bates versus Dow AgroSciences. So what exactly did the court decide there, and why is that precedent important to the preemption question that's before the court today?
Yes, well, as I mentioned, after the Supreme Court held that the congressionally mandated cigarette warnings preempted state failure to warn claims, we started seeing every regulated industry make the same argument that federally approved label preempted any failure to warn claims or other tort claims for their product. The courts were split on that. Interesting side note, the state Supreme Courts tended to find preemption less than the federal circuit courts, which may be that the state Supreme Courts are closer to states' rights. But that was kind of an interesting development. But eventually there was a split among the courts. So the Supreme Court took the issue in Bates versus Dow. It did not concern harm to health. Most of the cases I had been involved with to date had been about harm to health. But in Bates, the pesticide killed the crop. So it was a pesticide, it was a new one, that if it was used in acidic soils in certain areas, it caused crop damage. So it was a lot of farmers who were suing. And Dow said, no, you cannot bring tort litigation because there is an express preemption clause. There was a question at that time about whether preemption extended to common law duties at all, or was it just state-like legislation or regulation? So the language of the preemption clause is that states can regulate pesticide use, but they cannot have labeling that's in addition to or different from the federal requirements. And that requirement was used. State requirements couldn't be different than federal requirements. So the first thing in Bates that the Supreme Court held is that requirements includes common law. And so it can include a failure to warn claim. It can include a design defect claim. But then the court said, well, a lot of these claims, like design defects, those aren't about labels at all. So they're not preempted. The only one that could be would be a failure to warn. And the court said states can impose labeling requirements as long as they're not in addition to or different from FIFRA's requirements. And it specifically looked to the misbranding obligations under FIFRA. So a manufacturer has to avoid misbranding. There are a lot of definitions of misbranding, but two that are relevant here are a label cannot be false or misleading, and it has to have adequate warnings and directions for use to protect human health. So false and misleading, that could be equivalent to sort of fraud kind of claim, but that adequate instructions to protect human health can be very similar to a failure to warn kind of claim. The court didn't decide whether the particular claims at issue in that case were or were not in addition to FIFRA's requirements. It left that to be determined whether they are roughly equivalent, and that would be something that would be decided based on the state law. And it also said that EPA could exercise its authority to adopt regulations to fill in gaps, to basically define what would be misbranding. And if it did so, if it's done in accordance with delegated authority, that would have preemptive effect. And so we're seeing that play out now. What does that mean exactly?
I want to take a moment to ask what has changed legally or politically that's brought this issue back to the courts after the decision in Bates?
Well, I think manufacturers and Monsanto in particular just never gave up and kept trying to narrow what states can do under their common law in failure to warn claims. So I think right now what we have is most courts were saying that under Bates, failure to warn claims are equivalent to the misbranding prohibitions or obligations in FIFRA. And so they looked at it and drew from language in Bates that what Bates was talking about is the duty to make sure labels are not false and misleading, and the duty to make sure that they have adequate warnings and directions for use to protect health and also the environment if it were that kind of a claim. And they looked at those as equivalent and found that in most states, when they looked at it that way, and I think they might in all ways, is say that that's really an equivalent duty or legal standard. But Monsanto pushed for a different approach, which one of the circuits then accepted, which is to say, it's not about the duty, the misbranding duty. Instead, the Supreme Court said that EPA could adopt regulations and that those would have preemptive effect. And it didn't point to regulations defining misbranding, telling what has to be on the label, which there are some, but not for cancer. Instead, it looked at a different regulation that requires EPA to accept labels when there are major changes to them before the company can start using them. And it said that is where there is preemption now. It is because EPA has this, what the court said is a pre-approval label regulation that preempts anything else. And I mean, it's really not what Bates was talking about. In the Bates case, the pesticide at issue there that was killing the crops, during the course of the litigation, Dow, the manufacturer, changed the label. They kept submitting additional labels that EPA routinely accepted. And if you think about what EPA is doing there, their job is to make sure the labels are adequate to protect people. And the idea that the EPA will reject a label that's giving more information to protect people when there's no direct conflict with EPA's regulations on this branding or labeling, it's really counterintuitive to think that's what EPA will do. But that's the argument, that EPA is the gatekeeper and that it has to stamp those labels approved or accepted before the company can use them. So then that pretty much nullifies the idea that states can require labels that are in addition to, as long as they're not in addition to or different from what FIFRA requires.
And that argument was ultimately what divided the federal appeals court and brought this case before the Supreme Court. So can you walk us through how the different courts came down on this question and what's driving the disagreement?
Well, I'd like to offer my view about why the right answer here is the way most of the courts have approached it, which is what we're talking about here is equivalent legal standards, not whether EPA is a gatekeeper here. Because this statute allows state use regulations, which often find their way onto the labels. And under Bates, the court said that there can be additional state remedies for violating FIFRA's standards and pointed specifically to the misbranding obligation. So if a manufacturer has a false and misleading label, then states under that logic can provide additional remedies, like a failure to warn claim or a fraud claim. If a manufacturer has knowledge that people should not be applying this pesticide without protective clothing or with handheld equipment, or they risk getting cancer, It should provide adequate instructions on the label so people can help themselves and not get cancer. And for a state to say, we're going to apply our failure to warn liability to make sure manufacturers follow that federal legal obligation, that's an additional remedy for a violation of FIFRA. And so that should be the way that the courts look at this, not is EPA accepting the label. The argument that if EPA is receiving the label, but the company can't do anything in the meantime, nobody's proven that. There isn't evidence that that's actually happened. When there is a request for an amended registration, and that's the process for changing a label, EPA has to accept the label unless it would violate FIFRA. So the idea that EPA is going to say, we're going to reject the label, even if it would provide adequate instructions to protect health, seems like that is circular. If it's got to be looking at FIFRA's requirements, it should be the full set of requirements that would apply here, not just a procedural kind of review process that exists without content.
Thank you, Patti. You've laid out clearly how these arguments have evolved from the circuit courts all the way up to the Supreme Court. And with oral arguments approaching this session, the stakes couldn't be higher. But I want to take a step back for a moment, because regardless of how the court ultimately rules, this case carries enormous significance on its own. Why is that?
So a lot of the focus has been on express preemption, because there is an express preemption clause. But the other argument that Monsanto has made is an implied preemption argument, where it argues it would be impossible for it to comply with the state failure to warn jury verdict. And it's making that argument because of EPA's gatekeeping rule on most label changes. And so it's arguing that, what am I supposed to do? I get jury verdicts, and yet I have to submit the label for EPA to approve before I can make a change. Now, there is a doctrine of impossibility where the Supreme Court has said there has to be clear evidence that it is impossible. And that would include submitting a label to the regulator so that the regulator has a label in front of them and can then decide, is it false and misleading, or does it violate FIFRA's requirements, whatever they might find. That has never happened. Monsanto has never submitted a label with a cancer warning for Roundup. And another Roundup manufacturer did submit such a label, and EPA allowed it. And EPA has allowed cancer warnings on lots of pesticides, even though that's not something it does. It does not have a set of requirements for cancer warnings. And so the idea that it's impossible to make the change is really not a credible argument, particularly given how informal the approvals are, and that EPA allows minor changes without approving them, including to include state use requirements. One other thing I think is important for the listeners to know is that when the Supreme Court in Bates said that EPA can give meaning to misbranding through regulations, EPA has done that. It has a classification system for acute toxicity, and it requires disclosures on the label with different signal words that go along with the level of toxicity, like warning, caution, danger. And those words can only be used in reference to the acute toxicity of a product. There are also things like first aid descriptions that have to be on there, things like that. And that is all required by regulation, and it has preemptive effect. But EPA has no cancer warning system. It does not say you have to put anything on the label. It does not review labels for that. It does not prohibit warnings on cancer. That's just not something it's been in the business of doing. If it decides that a pesticide is a probable human carcinogen, it would then conduct a risk assessment that looks at that, and that might lead to some use restrictions or mitigation measures. But when it comes to warnings or precautionary statements, those are terms of art that go along with the acute toxicity system. And so when you have, there's a lot of slippery language in Monsanto's brief, in the United States brief, where they point to those regulations, but it's kind of a void. EPA just does not get in the business of deciding that there should be cancer warnings and what they look like. It also does not require any cancer testing of the formulated product. It only requires cancer testing for the active ingredient. So it's another void in what EPA is requiring as part of its process that undergirds the label.
I think what you're highlighting here, Patti, as well, is really one of the most useful aspects of litigation is that it illuminates areas in federal regulation, state regulation, where there are loopholes, where there are failings to protect human or environmental health, where maybe there could be more to be done, but because it's not there, and maybe because it's not there for a reason, that litigation plays a vital role in filling that gap. State law plays a vital role in filling that gap. It's part of the way that our legal system has been developed so that there's checks and balances between these operating parts of our legal system. And to say that one that doesn't adequately protect forecloses others that could more adequately protect or add opportunities for redress is a slippery slope and a slippery argument to make.
Thank you both for providing all of these valuable perspectives on the case that is before the court and that will be going into oral arguments. And as we're going into this session, why is this case so significant beyond one product or plaintiff? What bigger implications does it have?
Well, I can answer that from the pesticide perspective. So Cecilia might have an answer more broadly, but from the pesticide perspective, there is no mechanism for compensating people for harm that's caused by pesticide products. There is nothing in FIFRA allows people to sue for faulty labels, for harm that the products cause them. And that means that they're going to suffer. Like, I represent farm workers a lot. They are the most exposed to pesticides. There are acute poisonings. There are like chronic illnesses. If you have things like cancer or like reproductive harm, they're on the front lines and the most exposed and suffer the most. And they've got medical bills, lost work, what it costs to help raise a child that has learning or behavioral impairments, or to deal with a loved one that has Parkinson's disease. I mean, there are just so many hardships. And so there's the justice part of this, the part about having people who are harmed not have to bear the brunt of it when it's because of corporate wrongdoing. And so that's the other flip side. This is the way that companies who know their products cause harm conceal it from the regulators and continue to market the product because they can make money off of it. It's the way to hold them accountable, to learn what they knew and didn't tell, and to have that go to the regulators. And I can tell you from working on pesticide regulation for decades, it's slow. It's very slow. And it's always lagging behind the science. And even when EPA finally gets to a decision, it's under a balancing test where EPA can decide to continue to allow people to be exposed to huge risks because it will cost too much for the growers to shift to another pesticide.
Thank you, Patti. Cecilia, before we turn to the science, I want to bring you in here because the implications of this case may extend well beyond pesticides. What does this mean for toxics litigation more broadly?
Yeah, I think why this case is on so many people's radar, especially in the toxics space, it could have far-reaching implications. And it really depends on how the court rules and how narrowly it rules. But there is concern that it could have implications beyond pesticides and beyond FIFRA because it's getting at this issue of federal preemption and state failure to warn issues. And failure to warn claims are just a cornerstone of toxics and products liability cases. So generally, I'd say the court does a decent job of narrow rulings, but it doesn't mean that pulling on that thread won't lead to other issues of preemption outside of the scope of pesticides won't become an opportunity for another legal battle. This is what case law precedent is and sets, and at the Supreme Court, it's the highest stakes. So there are issues concerning PFAS and microplastics in particular. There are preemption labeling issues with the Food, Drug, and Cosmetic Act, especially with respect to bottled water and the presence of PFAS or microplastics in bottled water, where this could potentially come into play. And that's just one example of how far-reaching this could go or how this case could serve as precedent in other legal battles in the future. So it's something to think about. Hopefully, depending on what happens, a narrow ruling could avoid some of that. Or if the court rules that there is not federal preemption here and that failure to warn claims can continue, that is another way to bolster failure to warn cases in toxics litigation going forward. So again, this is all the issue of signaling and setting precedent and what it could mean for analogous types of law. And this goes back to what Patti was talking about at the beginning, that this relates to tobacco labeling way back, several decades ago. And a lot of toxics litigation is based on similar claims in the context of other toxic substances. So there's always the concern when the Supreme Court rules on something that it could have broader implications. It could have far-reaching implications. And when it comes to human and environmental health, that's always concerning.
Yeah, that's really pertinent, and I think that threat analogy is apt, and it raises a broader question about the Supreme Court's recent trajectory. We've seen a string of decisions over the past year that have significantly reshaped the relationship between federal agencies, Congress, and the courts, Loper-Bright being among the most consequential. So how might those shifts in judicial doctrine connect to what's at stake in this case, and should toxics litigators be paying attention to those trends?
Yeah, I think Loper-Bright will loom large in this case because Loper-Bright was saying that Congress has to decide in the statute what it is doing. What is it delegating to an AG? What is it saying about state law? And so preemption, particularly where there's an express preemption provision, is a matter of statutory construction. And then what did Congress mean by that? And it also said, unless Congress has delegated authority for an agency to fill in gaps in the statutes through rulemaking, then it is the statute that controls. Well, here under FIFRA, there is a delegation of authority for EPA to regulate. It's not just plain notice and comment. There's some other hoops to go through, like consulting the scientific advisory panel or the U.S. Department of Agriculture. But they can do that and adopt a regulation. They have done that with the acute toxicity misbranding regulations. But the argument that the United States is making here seems to clash with Loper-Bright, because what they're saying is whatever EPA approved on a label is definitive. It is, because EPA is supposed to determine, will the label violate FIFRA? Will it meet FIFRA's requirements? Will it be adequate? That therefore EPA's judgment in stamping a label accepted is deciding whether states have any role at all to play here. And that EPA stamps that label, it locks in, it preempts state failure to warn liability. And then if a new label is approved, then that decides that as far as the label can go. That is not a very conservative approach. That is not really an approach that is consistent with Loper-Bright.
And I think that's just demonstrative of exactly that, pulling the thread, that these Supreme Court decisions have really far-reaching implications potentially and get wrapped up into a lot of other meaningful cases that are being brought in other jurisdictions before the court. And it fits within the Supreme Court trends that we've seen as of late, where there's been challenges to really long-standing judicial approaches and challenges to long-standing balances between federal and state law. Now, that's part of the Supreme Court's jurisdiction and part of its history in general, but we've seen kind of an onslaught of it as of late. And it's unnerving in some ways to anticipate a potential change in such a major precedent.
Fantastic. Thank you both. And as a final question before we move on to our concluding thoughts, I wanted us to take a moment to think a little bit about the science. And I think this is particularly relevant not just with this case, but also when we think about agency deference and the kind of need for agencies to respond to changes in science and evolving science over time, right? So pesticides and toxics at large sit at the intersection of law and evolving science. And how does scientific understanding of risks evolve over time, and why does that matter legally?
Well, I can tell you why it matters for protecting people's health, and it's enormous. So I'll give two examples. One is in the area of children's health. We had a deficit in research and trying to figure out how pesticides and other toxic chemicals affect children's health. I think the assumption was if we're protecting adults, and particularly adult males, white males, that we're protecting everybody else. And there was a really pivotal study by the National Academy of Sciences in 1993 called Pesticides in the Diets of Infants and Children. And the message was, children aren't just little adults. They do different things. They breathe air at a rapid pace. They drink more water. They put their hands in their mouth a lot more than we do, hopefully. And so they're exposed in different ways. Their bodies are developing in utero and early childhood, adolescence, in very different ways where chemicals can have different impacts. And so one of the outgrowths of that was funding for children's health centers. And we have some really definitive studies that have followed mother-child pairs from pregnancy into the children's lives to adulthood that have found correlations between exposures in pregnancy and learning and behavioral impairments. And that is relevant to the organophosphates that I mentioned that I've been working on for a while. We didn't have that kind of evidence before, that studies had not been done. There are more studies too and other types of studies, but we've just started to fill a void in information. And the other example is right in our pesticide laws themselves. There was a mandate in 1996 for EPA to establish a screening program for endocrine disrupting chemicals. So those are pesticides that would mimic hormones, thyroid, estrogen, things like that. And there was some evidence that you could have really low doses have significant effects with those kinds of chemicals. So EPA established a program, but it hasn't done the testing. And so here we are 30 years later, where it's saying now maybe another 10 years it'll finish that testing. For one of the pesticides that goes by DCPA, it's called Dacthal, EPA got the tests for thyroid deficiencies and found that the levels that women are exposed to in pregnancy are at the level that could cause low birth weight and developmental and motor delays in their children and lifelong impacts. And when that came out, EPA actually suspended the pesticide, which is an emergency measure to say, we're going to stop its use now. And the company actually agreed then to voluntarily cancel that pesticide. But that's just one. And so you can see those delays meant that we haven't had that evidence and people have been exposed and children have experienced this harm while we're trying to catch up on science here.
Yeah, it's a vicious circle in some ways, and it's part of our legal system. We have somewhat reactionary laws rather than precautionary laws. And so the importance that scientific evidence plays in litigation is paramount to being able to establish your claims and your causation. But like Patti was saying, it does take time for science to understand and be able to prove or at least link harm to specific products, to specific chemicals, all of that. And I think we read about in the news so much. There's a new scientific study that says that we're consuming too many. I'm going to use microplastics as an example because it's such a good example right now because it's an emerging area of concern over toxicity. So there's a new study that says we have so many microplastics in our system. And then there's scientific debate over whether that study is scientifically sound, whether the methodologies have been developed far enough. So understanding what science can detect and how confidently they can link exposure to harm, that changes over time and it builds on each other. And it, as analytical tools, epidemiology and toxicology advance, the scientific evidence that's key to litigation either strengthens or weakens, and then the scientific consensus shifts with that. And I use the example of microplastics right now because it's really playing out in the news. And there was a big Guardian article that came out kind of discrediting some of the microplastic science that's happening right now. But then scientists wrote op-eds that are also recently published in the Guardian discussing this exact conundrum that scientific rigor is an evolving process and that as science evolves, it'll give us a better baseline understanding. But just because one study doesn't cover, because there might be gaps in one study, doesn't mean that science won't evolve from there or that the whole field has been discredited, essentially. And once our scientific basis gets strong enough, then litigation can be successful, really. And pesticides is much further along in that than a lot of other areas of emerging contaminants that are at issue right now. So there is greater opportunity for redress in that, and it does all of the discovery, all of the standard setting for what role and what strength science needs to be at, and litigation is helpful to look at between these areas of toxic substances to help inform other litigation going forward.
And I think it's important to remember in the pesticide context, what EPA is using for its baseline science is studies that are done by the manufacturers and not your kind of peer-reviewed independent science. And so it's got a scientific record that it uses for its risk assessments, but all of this other kind of independent science, academic science, peer-reviewed articles, the epidemiology, that doesn't factor in as much as it should into the EPA's regulation.
And as we look ahead to oral arguments, I want to give each of you a chance to leave our listeners with some final thoughts. Patti, starting with you, what should people be watching for when this case is argued before the court?
Well, I think there are three things to look out for at oral argument. One is FIFRA has a provision that says registration, which includes label approval, is no defense to a violation of FIFRA. So I think you should look for how that plays out. For Durnell, I think Durnell will be arguing that means that a label approval cannot provide immunity. And I'm not sure how Monsanto will play that. So I think that will be interesting. Second, I think you should look for Loeb or Bright to raise its head and see if the idea of what is the delegated authority that Congress gave EPA to preempt, essentially, and can approval of a label be enough? And then third, I think there'll be a lot of focus on whether it's impossible for Monsanto to change its label because EPA has to review most label changes. And so I think you'll hear a lot about that. And has EPA accepted cancer warnings or not? Did they need to have EPA acceptance or could they just be put on the label? So I think you'll hear a lot about that as well.
And then aside from this decision, what is the outlook broadly for some of the strategies to protect communities from pesticide or toxic exposure, whether it's through litigation, state action, federal reform, or even public engagement?
Yeah, I think, it will be quite a hardship if we lose failure to warn litigation in the pesticide context. But we'll just have to look at other ways that people can be heard and that, we can uncover corporate wrongdoing. There has been a lot of effort to try to get states to regulate, and they still have that authority. And a lot of that has gone through, like with chlorpyrifos, which I've mentioned, a lot of states adopted bans. And there was just pressure to do that. California is often a leader because it has the capacities to do its own risk assessments, and it has stronger laws that are more health-based in some ways than FIFRA. And so you have California doing its own analysis and even, sometimes pursuing an enforcement action that can uncover information as well. But that can provide a basis for people to demand that their governments, either at the federal or state level, protect them from harm. And some of it will be specific to a pesticide, but some of it has been trying to get protections for people who are near the areas where pesticides are applied. So to try to get protections in schools or around schools and playfields and daycare centers, so that we don't have pesticides wafting through the air and getting to our children. So I think that we'll just have to try. There are efforts by Monsanto and others to get preemption into legislation at the federal and state level so that even if there is a decision that is somewhat adverse, I'm sure they'll keep pushing for more. And in some of these, the MAHA groups have been an advocacy force against the preemption. And so they're out there being heard on this as well.
Yeah, I think it's North Dakota and Georgia have passed laws that shield chemical companies from financial liability for harms associated with pesticides right now. But in addition to, states taking efforts, and there are also efforts from both sides of this equation at the federal level as well. And there was a letter sent to congressional leadership by 130 U.S. representatives opposing any provisions that would nullify the right of states to take protective measures against pesticides. And congressmen from Kentucky introduced the No Immunity for Glyphosate Act, which would prohibit the use of federal funds to enforce. So as Patti said, this issue has allies from across the political aisle. And that's true of a lot of areas of toxics as well. People want to be healthy. People are concerned about these issues more generally. I personally am greatly concerned, not only for my own health, but my children's health. And the more we all understand about our exposure to toxic substances in general, it encourages people to act because it concerns our health and our environmental health. And it's something that can break down barriers across the aisle, and there can be unified efforts to protect human health. So I do feel some encouragement on that front, and I'm trying to be hopeful on that front that if litigation is foreclosed for some reason, that there are other opportunities in the regulatory space. But I think it would be a mistake to foreclose kind of the opportunity for litigation to play the vital role for checks and balances in this space.
Thank you both. And as a final question, what role can institutions like ELI and Earthjustice play in strengthening pesticides and toxics governance?
Well, I think our organizations are tracking what's going on. We see when there are opportunities for public comments, or if it's legislative, to contact your legislators and let them know you don't want legislation that is going to preempt people's rights to go to court and seek redress for harms. And so I think we can help people engage and be heard.
And I think our institutions working in the legal space can look at these issues more holistically and help identify opportunities for improvement of regulations. And like Patti said, highlighting opportunities for public comment and so forth, but also just raising the profile of these issues, talking about what's going on, helping people to understand ways that they can act and what can be done to help make our communities and really the world a healthier place.
Fantastic. Well, thank you both so much for joining me today. It has been an absolute pleasure having you on today's episode and learning so much about pesticides governance, toxics governance, and this very important case that's coming up during this session. So thank you both.
Thank you. Thank you.
And thank you, listeners, for joining us for another episode of People, Places, Planet. What's clear from this conversation is Monsanto versus Darnell is about far more than one herbicide or one plaintiff. It's about whether communities and workers harmed by toxic products can still seek accountability in court, and whether state law can continue to serve as a meaningful check on federal regulatory gaps. With oral arguments scheduled for April 27th, this is a case every environmental professional should have on their radar. The court's reasoning here could quietly reshape how we hold corporations accountable for toxic harms across the board, from pesticides to PFAS to microplastics and beyond. We'll link ELI's recent publication on current trends in toxics litigation and our FIFRA Explained episode in the show notes, so be sure to check those out. And if you found this episode valuable, please share it with a colleague or anyone who would be interested in this issue. And make sure you subscribe to People, Places, Planet wherever you get your podcasts so you don't miss our coverage as this case develops. Until next time.
Thanks for listening to People, Places, Planet, the official podcast of the Environmental Law Institute. Our work wouldn't be possible without the support of people like you. If you'd like to learn more about what we do, attend one of our events, or support our work financially, head to eli.org.